Supreme Court of Ghana has yet again attempted to clarify the law applicable to the distribution of spousal property following a divorce. All courts follow the Supreme Courts on matters of law, so when the Supreme Court speaks, we must listen. The story is told of AMMA and KOJO OWUSU SARPONG, who got engaged under customary law in 2002 and further took steps to register under the ordinance in 2005. The marriage was indeed childless, but KOJO had 2 adult children who never lived with the couple. KOJO was resident in the UK and assisted AMMA to join him. KOJO had started building a house at Kaswa prior to their engagement, but he only finished it during the pendency of the marriage. Cracks started to appear in the marriage. KOJO accused AMMA of saying hurtful words to the effect that he was simply not her type, and she had only agreed to marry him to secure her stay in Europe. AMMA also alleged a lack of sexual relations. Things had fallen apart. KOJO initially tried to initiate proceedings at the district court, but did not follow through. It was AMMA who took the first step and eventually filed for divorce in 2018 at the High Court in Koforidua. AMMA had testified that before she left for the UK, she supervised the construction of the building from lintel to window level. She stated that she had given KOJO £4,000, which she had saved for an IVF to aid her childbirth. She backed this with evidence of bank statements. KOJO alleged that he repaid it, and the bank statements AMMA tendered supported his story. All the same, the money found its way to the building project. She also contributed to the upkeep of the home in the UK, while KOJO paid rent and utilities. This was their own personal arrangement. The court on that basis awarded AMMA a 50% share of the house at Kaswa. KOJO was aggrieved and appealed to the Court of Appeal. The court agreed that indeed the building had the color of matrimonial property, but found that it simply was not equitable for AMMA to get half of it. Yes, she had provided direct and indirect support through her loan, the upkeep at home, and overseeing the building, which ensured that the building project progressed. But the land belonged to KOJO, and he had built up to window level before AMMA came in. AMMA undoubtedly deserved the share, but 50% was simply too much. The Court of Appeal rather gave her 20%. AMMA was aggrieved by this, and this is how the matter came before the Supreme Court. Her lawyers argued that the £4,000 payment, which was initially budgeted for her own healthcare, was never denied, nor was it repaid, and her major sacrifice should be entitling her to much more. A marriage, in her view, was not supposed to be treated as a commercial arrangement, so all her little contributions should be weighted appropriately, and it should entitle her to 50%. KOJO's lawyers argued that the evidence was clear. KOJO had acquired the land himself and had started the building to some level before the marriage. All money she gave him were in the form of loans that were repaid. He did not ask for less, only that the Court of Appeal's finding of her share being 20% to be maintained. Justice Akabuafo penned the judgment of the Supreme Court. A couple of key points had to be dealt with first. The court took the view that the Kaswa house could not be described as a matrimonial property. For a property to be described as a matrimonial house, there had to be a physical presence and an intent to make the place permanent. AMMA had never lived there, and it was clear that both parties never intended to live there. They were going to stay in the UK. It was therefore wrong to call it a matrimonial home. On the evidence, the High Court had also found that the bank statement proved that KOJO repaid the loan he duly received. Therefore, the Court of Appeal did not find it correctly. With that out of the way, the court ruled that the Kaswa property was indeed a jointly acquired marital asset. The jurisprudence as laid down by the court is that jointly acquired property is to be shared equally, unless the circumstances of the case demand otherwise. The court must always have regard to the equities of each case and divide the property accordingly. The court took the view that subjectivity must be removed from the manner in which courts come to a conclusion about property distribution. Once a court comes to a determination that a percentage of the property must be settled on another, they must provide basis using a 9-point framework. Considerations like duration of the marriage, ownership of land, the source of acquisition, premarital assets, and the like must guide the court. The Supreme Court took the view that the Court of Appeal was indeed correct. 20% was the most equitable portion to be awarded AMMA, and her appeal was dismissed. What do you think? Super Law GH Studios for more real stories, real cases, real people.